Today's courtroom session is packed with everything from drunk driving cases and emotional apologies to unexpected courtroom moments that leave even the judge shaking his head. You'll see defendants asking for second chances, attorneys fighting for lighter sentences, and a judge carefully balancing accountability with opportunities for rehabilitation. But don't be fooled by the calm tone. Some of these hearings take surprising turns, including one defendant who arrives at court apparently still intoxicated. Stay until the end because we'll break down why some people walk away with probation while others receive strict conditions, community service, and costly financial penalties. Every decision here reveals how the justice system weighs public safety against giving people a chance to rebuild their lives.
I'd like to say thank you to the court for getting us in early. We appreciate it.
No problem. Your name, ma'am?
Adriana Venegas.
Which one was it, John?
Yep.
All right. This is a drunk driving OWI. Does she stand mute and wait formal reading?
Yes, ma'am.
All right. I'm entering a not guilty plea for, is this a first offense?
Yes, Your Honor.
Allegedly, what was the reference?
I believe it was the IBAC. I'm going to take 2, 1. Don't walk from that, but I think that was it.
She is 20, just turned 24, right?
Correct.
All right. I'm gonna enter a not guilty plea. I'm signing your order for discovery. We'll set a pretrial date. I'm gonna give you a personal bond of $1,000. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm gonna order the man to not purchase, possess, or consume alcohol or illegal drugs, okay? I do want you going to NA at least one time per week. You have to go in person. We're gonna hand you a form. Every time you go, you have to have the form signed. And every time you come to court, you have to bring that form with you. Do you understand all that? All right. So what do you have for me, Heather?
It'll be February 18th at 9:30.
Is that good with you?
Thank you.
February 18th, you said at what time?
9:30.
9:30. Okay, that's what we'll do.
Thank you so much.
And you can, here, I'm gonna give her the form. You can just bear with me once. I'm gonna give her a copy of the bond sheet. And, whoa. Mutilated copy of the bond sheet. Jeez. There you go, ma'am. You can approach and we'll hand you that. And
It was a discovery order as well.
I signed that.
Thank you.
Notice how the judge immediately focuses on prevention rather than punishment. Although Adriana enters a not guilty plea, the court still imposes bond conditions designed to reduce risk while the case is pending. Restrictions on alcohol, mandatory attendance at Narcotics Anonymous meetings, and travel limitations aren't a finding of guilt. They are conditions meant to protect the public and encourage accountability before trial. Judges often use these requirements to monitor defendants and make sure they are taking the allegations seriously. It's also worth noting that failing to follow these conditions could create additional legal problems regardless of how the original case is ultimately resolved. What do you think? Is requiring treatment and regular meetings before a case is decided a fair safeguard, or should those requirements wait until after a conviction?
I did sign that, and you can go down the hall and they'll give you a copy of it, okay?
Thank you so much.
One other thing, you just double check something. Yeah, we're all set.
Thank you so much. Have a good day.
Have a good day. Thanks. All right. Audrey and Cousineau, 25F245225. All right. Good morning, Mr. Osmond.
Good morning, Your Honor. Jeff Osmond on behalf of Audrey Cousineau.
Your name, ma'am?
Audrey Cousineau.
All right. So your client pled guilty to operating while visibly impaired. She was referred for a screening and assessment. Any material additions, corrections, or deletions?
No, Your Honor, and I would indicate to the court that she does have her AA sheet here. She's been attending.
Okay, and you've seen that?
Yes,
She's
sir.
been going at least once per week?
Yes, sir.
Okay. What else would you like to say?
Judge, I've spoken to her at great length about this incident. She takes it very seriously. She is going to do everything she can. She has no was totally out of character for her. No prior history with law enforcement or anything of that nature. Comes from a good family. And I'm sure we won't see her again back here.
All right, ma'am, is there anything you would like to say?
I would just like to say I'm very sorry and I fully learned my lesson from this.
Okay. All right, good enough. I don't usually only go 8 months, but she scored in category 1 on everything, so I'll go along with that. 8 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You do have to report as directed, no alcohol, no illegal drugs, no marijuana. You can't go to any place that sells or dispenses alcohol. They're recommending bi-weekly testing. I'll go along with that, but I'll only make you test bi-weekly for 3 months. If you're clean, then I'll make it monthly, okay? Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. Attend a level 2 alcohol education program and the Victims Impact Panel. That's one night put on by Mothers Against Drunk Drivers. 4 days jail credit, 1, serve 3. I'll let you serve those by way of community service. So 3 days community service, that's 24 hours. And I'm going to give you until March the 25th to complete that. So you got about 7 weeks, okay? So 24 hours community service. You may be eligible for early discharge. You're going to pay fines of $300, costs of $300, $75 victims' rights fee, $50 justice assessment, 7 1/4 probation fees. $160 for a total of $885. You have a screening fee of $60 for $945 plus your cost of recovery. Everything included amounts to $1,170. Again, if there are no violations, you can apply for early discharge in 4 months. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yes, I understand.
Judge, I'm sorry, could I ask for, she'd asked me earlier, a family that she grew up with is going to Mexico from the 20th to the 26th and invited her to come with them if she could have permission to do that.
Yeah, these states, these countries, I don't know who lets who in. I'll just say she can leave the state. I'm not saying she can go to Mexico. You need to double check, make sure there's no problems. I'm sure there's not.
Yeah,
But like Canada, you can't go into Canada.
Canada would be an issue, you're right.
You can leave the state between February the 20.
To the 26th?
I'll make it the 27th in case the flight gets delayed. How's that? Okay. And can she pay all this today or does she need time?
I can pay all this today.
All right. I wish you well, and then you'll meet with probation, okay?
Thank you.
Best of luck to you, man. Thank you.
This hearing shows how much a defendant's conduct after an arrest can influence sentencing. Audrey accepted responsibility, completed her required AA meetings, had no prior criminal history mentioned, and expressed genuine remorse. Those factors appear to have persuaded the judge to impose probation instead of jail, with community service replacing the remaining custodial sentence. Even the request to travel received careful consideration. Rather than automatically approving international travel, the judge made it clear that leaving the state was authorized, but entry into another country depends on that country's own laws and border policies. That's an important legal distinction many people overlook. Accountability doesn't necessarily end opportunities, but compliance, honesty, and preparation often make a significant difference in how the court exercises its discretion.
Thank you.
Thanks, Mr. Osmond.
Yes, Your Honor.
Liliana Marie Vanderhoof, 26W841159 A and B. Your name? Charged with driving on a suspended. You have the right to a lawyer. If you want one, I'll give you one. I can't hear you.
No.
You waive your right to a lawyer?
Yes.
On January 4 of 26, it is alleged that you did operate a motor vehicle with a suspended license on I-75 near West in Woodhaven at 1:27 in the morning. That is a misdemeanor. It is punishable by up to 500 fines, 93 days jail, costs, or all those in 2 points. Do you understand that?
Yes,
Did you sign the advice of rights and read and understand the rights?
yes,
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that? You have the right to a lawyer, as I said. Do you still wish to waive your right to a lawyer?
yes,
I'm gonna enter a not guilty plea, $500 personal bond. You don't have to post any money. Here are your bond conditions. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. So those are your bond conditions. You'll owe the people of Woodhaven $500 if you violate any of those. And I'm entering a plea of denial on the speeding. You understand that?
yes.
So you're gonna go talk to the prosecutor and then you'll come back in here, okay? Thank you. Lori Hinkle.
Yes, sir.
Lori Gay Hinkle, 26W841130A and B. Your name?
Laura Gainville.
You smell of alcohol, I'm told, Ms. Hinkle. Are you
I
drunk?
was drinking last night.
Are you drunk?
No,
We're gonna give you a PBT, okay? You're gonna, my court officer is going to administer a PBT to you.
I
So,
was drinking until,
ma'am,
Go ahead and see the hallway.
we're gonna administer a PBT to you.
Go ahead and see the hallway.
And you'll go out and, so that goes to the prosecutor. That's the PBT. People against Labadie. Reed Dean Labadie Jr. 25W82910.
Morning, Your Honor. Tim Gamber, the applicant, Glavity, who's also present. This is the time and date set sentencing.
Your name, sir?
Reed Glavity,
All right, I want to make sure, first of all, have you had a chance to review, he pled, by the way, to this, under height at a window peeping,
That's correct.
and, he was to go to AANA twice a week. Have you
Yeah.
seen that form?
10 visits.
He's been doing that? Okay,
Yeah.
good.
Should I submit this to your clerk for copy?
No, that's all right. I trust you. He's gonna need to keep that, okay?
Well, he's been doing really well on that.
Good.
Very seriously. Whenever you're ready, I can address the PSI.
Yeah, have you had a chance to review the report? And are there
We
any-
did, we looked it over this morning. I went over it with my client. The only real issue is that we had, seems to me like outpatient counseling is a bit extreme. If he's testing twice a week, he's been clean, he's been following the court's recommendation and order. As far as AA goes, maybe if the court was inclined to entertain that particular element, that if he tested positive, maybe that it could trigger outpatient. Because he expressed to me this
Well, I
morning.
mean, I think their concern is, he had THC in his system. He acknowledged he was using marijuana and he had 10 beers and now he's going in the backyard of somebody's house and window peeping. I mean, I don't think it's that extreme, but I get it. Go ahead. I'm sorry. I didn't mean to interrupt.
No, and I think that's a very valid point, and I think that's something that he expressed to me this morning was that, I think he's relieved that this ended where it did, and it didn't result in something more extreme. I mean, people get shot for stuff like that. And that was something that he expressed to me was that, in the grand scheme of things, the severity of it was probably as minimal as it could be. But Judge, yes, I would say that, given the fact that going to 2 AA sessions per week and has, weekly or bi-weekly testing, whatever the court would order on that. If he did test positive and he's quit smoking marijuana for the most part, I think. If he tested positive for alcohol or drugs, any illegal drugs at any point in time, then at that point in time, couldn't that trigger an outpatient program?
That's your argument.
Yes.
I got it. Anything else? Either one of you?
Reed, you have everything?
I just want to say that was a dumb mistake and I'm glad it turned out the way it did. Could have been a lot worse.
And you went over and got fingerprinted, right?
Yeah, I did, right after the last court date.
By the way, I just need to ask, is there a Tyler or Brooklyn Wilson here? All right.
Drop this off.
All right, I'm gonna take this under the Vehicle Training Act. As agreed upon, that's what you guys agreed upon, I'll do that. 15 months probation, you cannot leave the state without the consent of the court, you cannot violate any law or ordinance. You change your address, place of employment, or home telephone number, you must notify probation, you have to report as directed, no alcohol, no marijuana, no illegal controlled substances, you're not to purchase, possess, or consume any one of those, you're just kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing PBTs bi-weekly for 4 months. If you're clean, I'll then make it monthly. No contact with Brooklyn Wilson or her family members. No contact with her or her family members. You're not to enter the property or go near the property address of 19116 Hyde Park Court in the city of Woodhaven. I'm gonna order 4 days jail. I'm gonna let you serve those as follows. 3 days on the court work program. There's a $35 a day charge for that for a total of $105. And 1 day or 8 hours of community service, which you have to complete in this case by March the 20th. I am gonna order that you continue attending AANA twice a week in person until you're in outpatient treatment. I'm gonna order outpatient treatment as well. We're to attend that and complete that. Fines. So you understand the sentence so far?
Yes.
Fines are 100, costs are 200, 75 victims' rights fee, $50 justice assessment, 4 and a quarter, screening fee 60 for 485. Probation fees are 300 for 785 plus your court work program fees. Your total's 890. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford them. You understand that?
Yes.
All right, that's what I'm gonna do. Does he have all of this to pay?
I'm sure he probably would need some time to make payments, Bill.
How much do you have today?
I didn't want to pay it all time sheet.
I didn't ask you that. How much do you have to pay?
I can pay 100. I can pay 100.
$100 now, 75 a week, you can do that, right?
Yeah.
75 per week, I'll give you a little bit of leeway or give you a little bit of a head start, so to speak. So I won't have you pay this until February the 27th, and you'll meet with probation. And if you ever don't have the money, you call the clerk and on Zoom, I'll give you an extension, okay? Honor before the duty. Good luck. Thanks, counsel. Lori Gabe Hinkle, 26W841130A. And B,
Yes.
you're drunk.
Well said. I still.
You said no, sir. What's your name? Tell me your name.
My name's Lori Gainville.
You got a .166 on the PBT.
I was drinking until 4:01 and I didn't, I did. No, that I couldn't believe that was.
You're still drunk.
No, it was.
Man, we've got a .166. Who drove here?
My friend.
Who's- Is this the guy here? Did he drive?
Sir Ronald Raymond Hamilton, the left president.
Slow down.
President.
What?
of the United States.
Hang on a second. Who?
The 11th cousin to the United States president,
What's his name?
Sir Ronald Raymond Hamilton. The cousin to the president.
You ready?
Yeah.
The president of the United States,
Yes,
the president right now,
yes, sir.
he's shaking his head no. Why is he shaking his head no? If he's not the president, why?
No, he's not president, he's the 11th cousin.
11th cousin. He's shaking his head no. That he's not the 11th cousin. And honestly, I don't care if he's the brother of the president. It's not going to help you, so I don't need to hear this. What I do want you to know, if you show up for court again drunk, we're going to have a big problem. I'm going to reschedule your case. Sir, you cannot let her drive. Do you understand?
Thank you, Trish. You know.
Well, you know, you got it.
Pledge allegiance.
I'm sorry?
Pledge allegiance.
Pledge allegiance? Is that what you said?
Yes.
I'm unjustified.
Just relax. Heather, give me another date, will you please? I should probably have you locked up until you go down. Give me another date.
This is easily one of the most dramatic moments of the hearing. The judge suspected something wasn't right almost immediately, ordered a preliminary breath test, and the result confirmed a blood alcohol concentration of 0.166, well above the legal driving limit in most jurisdictions. Instead of escalating the situation into an immediate custody decision, the judge focused on preventing a potentially dangerous outcome by making absolutely certain she would not drive away from the courthouse. The confused responses about the president only reinforced the court's concerns about her level of impairment. This exchange is a reminder that courtroom behavior matters just as much as the underlying charge. Appearing before a judge while apparently intoxicated can seriously damage credibility and may influence how future proceedings unfold. Do you think the judge handled this situation appropriately, or would you have expected a harsher response?
We can do February 18th at 9:45.
Come on up here, sir. What is your name?
My name is Ron and
Did you drive her here?
yes, I did, in fact, not the alcohol when she got up.
You live with her?
She stayed with me last night. She asked me 2 days ago if I'd come with her. So really happened. She left my house when she got
Is she gonna have access to a motor vehicle?
no. Not that bad.
Do you own a motor vehicle, ma'am?
That's what
Does she?
a 2010 Ford Focus, light gray.
Well, hang on a second. You just told me she didn't have access. If she owns a motor vehicle, how does she not have access to the vehicle?
I'm the phone when we not just. I picked him last night.
Go down the hall, get your new date. It's going to be February 18th
February 18th.
at 9:45 in the morning.
You think 45 an hour, no alcohol.
Don't show up drunk. Don't show up after consuming alcohol.
Okay, sir.
We understand?
Okay.
Sir, I'm gonna let her go. I'm gonna trust you're not gonna give her those keys.
Thank you. I'm trying to try to get her into a treatment center for alcoholism.
All right, let's not have any further discussions here, okay?
Okay.
That's what I'm gonna do. Do not drive. Do you understand?
Yes,
Do not drive. You understand?
yes,
Sir.
Go down the hall. They'll give you a notice. Thank you. Raymond Kirk Hamill.
Good morning, Your Honor.
This is file 26W840317. Good morning, Mr. Gilbert. How are you?
All right. Would you like my appearance?
Yes, please.
Mark Gilbert, P71034 for Mr. Hamill, who is to my left.
Sir, your name?
Your name?
Raymond Hamill?
All right. Can he get a little closer or speak louder?
I can.
Come on up here, Mr. Hamel. Tell me your name again, please.
Raymond Cargamel?
All right, so, Mr. Gilbert, for purposes of arraignment, does he stand mute and waive formal reading?
We do, Your Honor.
And then you pre-tried this with the prosecutor, true? And he's going to plead guilty to the added count of operating while visibly impaired with the OWI to be dismissed, true?
That is accurate.
Is that what you want to do, Mr. Hamel?
Yes, Your Honor.
If you do that, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. You have the right at a trial to testify or remain silent with the understanding that if you choose to remain silent, that silence would not be held against you. You have the right to cross-examine the prosecution's witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena powers of the court to bring in those witnesses. And if you plead guilty, you'll be giving up all those rights, and we will not have a trial of any kind. Do you understand that?
Yes.
All right. You understand when you plead guilty here today that you're giving up the rights, you're waiving the presumption of innocence, and you're waiving the requirement that they prove you guilty beyond a reasonable doubt. You understand that?
Yes.
All right. To the charge operating while visibly impaired, how do you plead?
Guilty.
Were you operating a motor vehicle in the city of Woodhaven, County of Wayne on January 4th of 26 on Allen near Van Horn at 2:59 in the morning?
Yes.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Yes, and about 6 beers.
Okay, was your ability to operate that motor vehicle impaired because of the alcohol consumption? And if so, in what way?
Yes.
How?
Drunk.
Well,
I know, but why were you
What
pulled
happened?
over by the police? Were you
Oh, I
weaving,
was,
swerving, speed?
Sorry, sir. I was sleeping. Well, the train pulled up and I put my car in park and I fell asleep.
I see. You think you did that at least in part because of your alcohol consumption?
Yes.
And did you take a breath test or a blood draw?
I did breath.
And counsel, were the results 0.136 and you so stipulate that that was an accurate reading for purposes of the plea?
There were actually 2 BACs, and yes, I stepped, Your Honor.
Are you on probation or parole, sir?
No.
Anybody forced you to plead guilty?
No.
Plea is accepted to that charge operating while impaired. The OWI is dismissed. He is 32, right? All right.
I'm 32.
I'm going to give you a personal bond of $1,000. I'm going to order a screening and assessment. John,
Yeah.
go over to probation, see if they can screen and assess him today, will you?
Okay.
You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I do want you going to AA 1 time per week.
Yeah, what's the first name?
Hamill. We want to check and see if they're going to be able to screen them. They're really busy over there right now. Or do they want me to set a date? Okay, I want you to call over to probation. 734-671-0201. That's 671-0201. Extension 245 and see when they want him to come in. They're really busy. They're not gonna be able to do it right now. So, and I'll give you a new sentence date or a sentence date and we'll go from there.
Thank
What do
you,
you
Your
have for me, Heather?
February 18th at 8:30.
At 8:30, council, okay?
Yeah, do you need us by Zoom or in person on that day?
I mean, if he's gonna be in the only, I want sobriety court cases by Zoom, I mean, in person. Other than that, if they're, if he's in your office with you, I don't have a problem with Zoom, okay?
No worries.
Either way, so you both show up here or you both show up there.
Thank you,
February 18th, 8:30. Anything else?
Nothing, Your Honor. I will call probation and try to get a schedule.
Thank you. Have a good day.
Thank you, Your Honor.
Thanks. Kevin Hudson Sterling. 25W839-175.
Good morning, Judge and staff. John Graziani appearing on behalf of Kevin Sterling. Today is the day set for sentencing. Please identify yourself. So,
Good morning, Mr. Graziani. So your client pled guilty to retail fraud, and the agreement was it would be taken under 771.1. He was referred for a pre-sentence report. If you had a chance to review the report with him, and are there any material additions, corrections, or deletions? And by the way, there was an agreement, it says 12 to 18 months. But there's an agreement for restitution of 482.36, I believe.
that's correct, Judge. And he's in a position to pay it. And is in a position also to make a $300 deposit for his funds for costs.
Okay, what would you like to say, counsel?
Judge, there's the only
And your name again?
Kevin Sterling, Your Honor.
Go ahead.
The only modification, Judge, that we're asking for is that in lieu of the court work program, we're asking for Mr. Sterling to participate in volunteer services and comparable hours. But other than that, we're satisfied.
Anything you'd like to say, sir?
Yeah, I just want to say I apologize for my behavior. It's been a very humbling experience, and I can just assure you I won't be in here again.
You know, I guess what bothers,
We do have the fingerprints over here if you'd like to put in the file.
the fingerprints?
We have the order for the fingerprints.
Oh, yeah, he already went and got printed, right?
That's correct, Judge.
Yeah, we can take that. Thank you. I think what bothers me is they knew you were doing this repeatedly. I mean, they called ahead. They knew you were going in there and stealing. This wasn't a one-time thing. I mean,
Judge, he is in a program right now and he's been aggressively attending it. And I told him essentially that he's on probation for the rest of his life. That's why I had no problem with the evaluation. And it can be used as a blueprint for him to play the rest of his life.
the evaluation, he's in a psychiatric,
He's receiving treatment at this time, Judge.
at where?
Got the new patient was in Taylor. It's evolution, mental health.
Okay, I'm just gonna say attend mental health treatment at a facility approved by probation, okay?
Thank you, Judge.
All right, 12, did I let everybody finish?
No, we're fine, Judge. We're fine.
12 months probation, you cannot leave the state, and I'll take it under 771.
Thank you, Judge.
You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court with probation as directed. You're not to have any contact with employees of the Woodhaven Aldi store. You're not to enter 20076 West Road in Woodhaven or any other Aldi store. You're to attend the mental health treatment at a facility approved by probation. I'm not going to order the positive strategies, but you are going to serve 3 days on the court work program. There's a $35 a day charge for that for a total of $105, and I'm going to have you pay restitution of $482.36. I'm going to have you pay fines $100, costs $100, $75 rights fee, $50 justice assessment. So you have that, that's 3 1/4, screening fee 60 for 385. You have probation fees of 240 for 625. You have court work program fees of 105 for a total of 730 plus your 482. So that should be $1,212.36. That includes everything. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. If you're compliant, the case will be dismissed at the end of a year on motion of the prosecutor. I'll give you a review hearing date. If you're not compliant, this will go on your record. You'll be subject to a 90-day jail term. Do you understand that?
Yes, Your Honor.
All right. Counsel, how much does he have today?
He's got $300 to put down for the fines and court costs, and how much do you have for restitution?
I can pay the restitution today. Fully.
Do you have $800 you can pay today or not?
Yes.
You pay $800 now, and then I'll let you pay $100. I'll let you pay $100 bi-weekly, and I'll start that beginning next Friday, which is the 13th, okay? Give me the review hearing date form, Heather, please.
That'll be February 3rd.
February 3rd at 27 at 8:30 in the morning. We'll give you a notice. Make sure you put it in your calendar. You have to show up that day. Any questions? Okay, so you'll meet with probation. I don't know if they'll be able to instruct you to, but go down the hall, pay your fines, and we'll go from there, okay?
Judge, thank you so
But
much.
you have them check in with probation. Thank you, Mr. President. What's this? Michael James Lee.
Frost on custody.
Today's docket demonstrates that every case is unique, even when similar charges appear before the same judge. Some defendants earned more lenient outcomes because they accepted responsibility, completed treatment requirements, and showed genuine efforts to change. Others faced stricter supervision due to the seriousness of the facts or concerns about public safety. Throughout these hearings, the judge consistently emphasized rehabilitation, compliance, financial accountability, and protecting the community rather than relying solely on incarceration. Whether it involved OWI offenses, suspended license charges, retail fraud, or probation conditions, each ruling reflected the court's attempt to balance justice with the possibility of rehabilitation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and in-depth legal analysis.